Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. I'd like to talk to you a little bit about something that is very important to your job, and that's what is commonly referred to as Brady Lists. And these are databases and lists that prosecutors keep in order to fulfill their obligation to the court and to defense attorneys in providing exculpatory information, and more specifically, impeachment material about you. And so let's talk a little bit about the genesis of this Brady List. In every case, no matter who the witness is, NRS 50.085 allows defense attorneys to cross-examine witnesses about truthfulness. They can get into someone's opinion about your truthfulness. They can cross-examine you about specific instances which involve an element of truthfulness. And so courts around the country have imposed this obligation on prosecutors to disclose information dealing with your truthfulness or reputation or aspects of your truthfulness. And so it starts with Brady versus Maryland. You've all heard about that case, Brady versus Maryland. It is a constitutional rule that says that if you have exculpatory evidence which tends to explain away charges, police and prosecutors are obligated to turn that over to the defense. There is a corollary case called Giglio versus United States, and that case dealt with a situation where a witness was promised that he was not going to be prosecuted if he testified against a criminal defendant. He denied that on cross-examination, and unbeknownst to the prosecutor, another prosecutor had made that promise to the witness. And the U.S. Supreme Court said that was Brady material, that was impeachment material that should have been turned over to the defendant. And so those are the two U.S. Supreme Court cases that deal with this issue. There's a Ninth Circuit case called United States versus Henthorne, and that case imposes upon federal prosecutors the obligation to actually go into your personnel file and research for evidence of impeachment material for you. And that happens in every federal prosecution. So if you're a task force officer or just an officer who has made an arrest that results in a federal prosecution, your personnel file will be turned over to federal prosecutors to review for impeachment material. And if there's a close call, they're required to turn it over to the federal judge for what we call an in-camera inspection, where the federal judge reviews the material by him or herself and determines whether it is impeachment material. Today, more than ever, it's so important for you to be truthful, to be prepared when you go in and testify. Just recently, we had a federal magistrate who was a former federal public defender who issued a decision in a suppression hearing which concluded that the metro officers were not credible. The U.S. Attorney did not appeal that decision, and at PPA we brought in a private investigator who's a former Metro sergeant, and we conducted additional investigation to establish that the officers were in fact truthful. Their testimony may have been sloppy during the hearing, but they were not lying during their testimony. So on a state level, I know this sounds a little bit rambling, but there are different parts to this issue. When I was district attorney, we set forth a policy that we felt gave officers their due process, and the standard back some 10 years ago was that if an officer had a sustained complaint for truthfulness, that information would be disclosed to the court and the defense attorney. The idea was that if the complaint was sustained, the officer had the ability to contest the issue and take the issue to arbitration under the collective bargaining agreement. So what is the takeaway from this? Obviously, you have to be so careful when you testify, and always make sure that you follow the 10 tips for testifying that we just discussed. Make sure that you are clear in your answers, and if you're placed on a Brady list because you have a sustained complaint for truthfulness, don't worry, it's not the end of your career. You can still testify in cases. It's just that a judge will have to determine whether the information should be presented to a jury, and of course the prosecutor will be able to try to explain the circumstances of your truthfulness violation. And of course, if you have corroborating evidence in the case, your case is not completely lost based upon your Brady issues. I hope this helps provide you some guidance on this issue. As always, if you have questions, please contact me at droger@lvppa.com and check out our website, davidroger.us. Thank you.